local level of government in the United States. And again, I want to talk to you about U.S. government today. My name is Jeremiah Graham, and I attended George Mason Law School, and I was a professor of international law at Kashmir University in Srinagar. And I've really studied U.S. law and U.S. constitutional law and comparative constitutional law, and looking at the different frameworks for limited government throughout history. And the United States obviously has been the most successful and the model for limited government. And one of the things that makes it so unique is that we are the only nation that has what's called a true federal system. And the federal system means that our power structure is diversified. It's not centralized power structure. And we see that in the government's response to COVID-19. So to give you a little bit of a backdrop, the United States Constitution enacts and enumerates limited powers for a federal government that are over these United States. When it was originally written, as you all know, there were 13 states. Now we have 50 states and a few territories, and it looks like there have been movements towards changing the size and the structure of states, but none of that's materialized yet. We've maintained 50 states for a while now. The federal government oversees those 50 states, and in the enumerated powers that the Constitution gives the federal government, it's a very limited scope of powers that doesn't allow them to do a lot of things. Most power is reserved to the states, and then the states get to decide for themselves how much power they have over their citizens. Now, what we see here is not a case of federal overreach. While the federal government has led the response to COVID-19 and done a lot of things in that response, nothing that the federal government has done has been enforced at the local level. And it's been very clear about everything that it's said in every document that it's produced that all it's doing is providing guidance to the states, not requiring them to follow some kind of federal mandate. That's, again, very unique to the United States response. Elsewhere, like in India, they have I actually got to preside at Kashmir University over a debate about comparative constitutional law, asking, is the Indian Constitution federal? So again, a federal constitution means that the power is not centralized at the federal level, which is, it's kind of a funny thing to think about, because it's called federal, which means it's got a weak federal government. It's not a strong federal government. But in India, the Prime Minister and the Indian Parliament are able to enact laws and require the entire nation to lock down. And a lot of people recommended to our President Donald Trump that he lock down the entire nation. But he chose not to, and said that that's something for each state to decide, which shows that he recognizes, and the people advising him recognize, that the federal government doesn't actually have that power and that ability to be able to institute a nationwide lockdown. If you actually look and see where the Center for Disease Control, the CDC, says that it has the power to isolate and quarantine people who are a public health hazard, they'll find it in one particular clause of the United States Constitution. Again, the federal government has certain enumerated powers, and it's limited to those enumerated powers, and those enumerated powers were written with the principal purpose that the federal government would handle foreign affairs and disputes and interactions between states. And one clause is a clause that allows the federal government to regulate interstate commerce. It's not written exactly that way, but that's how it's been interpreted. And because of that clause and the way it's been interpreted by the Supreme Court, a lot of times the federal government has been allowed to use a lot of power saying that it's regulating interstate commerce. So the CDC says that if they were to isolate and quarantine people who are considered a public health hazard, that power would be found in the Commerce Clause. And there's a lot of power that's there embedded in the Commerce Clause, and that's the most broadly read clause that gives the federal government power. But in this case, the federal government hasn't used that power that the CDC claims that it has, in large part because President Trump and the people advising him recognize that that's an improper reading of the Commerce Clause. And that's one of the things that sets apart conservative from liberal governance. Liberal governance and really liberal jurists who are sitting on courts tend to interpret the Commerce Clause very broadly. Conservative jurists tend to interpret the Commerce Clause very narrowly. And there's been a lot of scholarly articles written about the Commerce Clause and analyzing it, and I don't want to discuss it too much, but I want you to understand that when the federal government is doing anything, they have to look into the Constitution and find where that power is located. And in this case, they decided that they didn't have the power to do anything. And that's something that goes against the idea that the federal government or Nancy Pelosi or certain individuals are trying to control the U.S. response, whether it's the CDC or the World Health Organization or even Dr. Fauci, that they're trying to control the United States response to COVID-19. It's just simply not true, because everything done on the federal level has just been in the nature of guidelines. Now, what we do see is we see exactly what the framers of the Constitution intended to happen, happening at the state level. In the United States, we have 50 states. And so, on a federal system, we should see 50 different responses to COVID-19, and that's what we've seen. Every state is doing it different. There's some categories. You can categorize certain states in the same category of response. For example, California and New York have very similar responses. South Dakota is on the far other end of the spectrum, and there's other states that are categorized as free states because they have very limited restrictions that they're placing on the citizens of those states. But again, it all comes down to what was intended, which is that each state would be allowed to respond to crises in its own way. In fact, the Constitution includes in it a clause that gives states every power that the federal government doesn't have, every power of sovereignty that the federal government doesn't have, and that includes the police power. So when you're talking about a police state, each state individually has the ability to decide how they police themselves. And so when in looking at the federal guidelines, a lot of states have responded in different ways. Again, categories. You look at Texas and Florida and Louisiana and other states like that, they seem to be following the same kind of pattern, painting with a broad brush, but there's categories of different state responses. Now, we might look at it and say, from our perspective, that South Dakota has had the best outcome and the best policy. But the principle of our federal Constitution was that what's done in South Dakota wouldn't be required in California. And for better or worse, in California, we've decided to have a very strong response to COVID-19. And again, that's a policy decision made by elected representatives. Now, there's a couple ways this breaks out. So the federal government's instituted guidelines, and California decided that I'm going to use California as an example because I'm living in California, I'm practicing law in California, and I've spent a lot of time with the California statutes. But you look at California's response, Governor Gavin Newsom made an executive order adopting the state public health officer's order, and this is the same way it's done in a lot of other states. And the state public health officer pointed to the federal guidelines and said, well, the Department of Homeland Security, which is one of the many departments of the federal government that are responding to the COVID-19 crisis, California said the Department of Homeland Security has, through its what's called CISA, the Critical Infrastructure and Security Agency, they've decided that there are 16 critical federal infrastructure sectors. And if any of those 16 sectors close down, then it's going to be bad for the nation and for the economy. Now, if you look at those 16 critical infrastructure sectors, they're so broad that it's hard to paint anything out of them. For example, they include one called commercial facilities. And by commercial facilities, they mean places where the public tends to congregate for commerce. And they include in there sports arenas and stadiums and casinos and outdoor events and different things where a wide part of the community tends to come and gather together. Now, that's a pretty broad category of things that initially in Governor Gavin Newsom's order were completely exempt. Well, the state of California then looked at those 16 critical infrastructure sectors after adopting all 16 of them, and then thought about it, and on March 22nd, they published a list of 153 broad bullet-pointed categories of exemptions and said, well, this is how we interpret the 16 critical infrastructure sectors that the federal government identified, and this is what we think is essential to California. Again, what California does doesn't affect what the rest of the nation does, and it's the same for every state. But that's what the California state level response was. Well, they decided, and what was very close to our heart, was they decided that churches were essential, a part of an essential category, and other religious groups, and they termed it under the term of faith-based services, and they just put in there faith-based services provided through streaming or other technology. No one knew how to interpret that. And that's where this gets really muddy, because that's the state level response. But by and large in California, we haven't seen state level enforcement. We've seen local enforcement. And so in interpreting the state level statutes, we have in San Diego County, and again, I'm going to use the example that comes closest to home for me, but it's the same in your municipality, in your local government area. There's a lot of different states that have different local government entities, and the way they're structured, it changes from state to state. And that's how the founders intended it. They wanted it to be what they called an arena for the competition of ideas, so that everyone would be able to see the different policies at play and decide which one worked best, and be able to move freely between the states and say, well, this is my new residence because I like the policies over here better than the policies over there. And that's called voting with your feet. And it's something that the Founding Fathers intended to be done. Now, San Diego County took what I described to you, the 153 bullet-pointed exemptions from the state level, and they had to interpret them. And so they issued an order. Governor Gavin Newsom's order and the state public health officer's order was a whole entirety of 2 pages. Well, San Diego County got a hold of it, and they originally did a 6-page order, and then it grew to 7 pages, and I think we're at 8 pages now, and it's still growing. And that's their interpretation of the state order. And what we have in California is, at some point, the elected officials, the elected government that we created in the legislature of California, passed a very common law that's probably in your state as well if you're not living in California, and it's a Health and Safety Act. And there's model health and safety acts that have been proposed by the federal government, but again, no state has to follow those sorts of things. The Health and Safety Act in California says that in an event of an emergency, the public health officer in a locality can take any protective step necessary to protect the public from an actual public health hazard. Now, there's a couple different ways to interpret it, but in California, it's never been challenged in a court. There's no precedent for how it should be interpreted, and I tend to think that it should be read narrowly, because it says abatement, correction, removal, or other necessary protective step, or just not even necessary, other protective step. But in California, the County Council of San Diego County and the California across the board in all the different municipalities, they've interpreted that to mean that the state public health officer can make an order that applies to everyone in the county and require them to stay at home. And that's all in the phrase other protective step, which is funny because it's the same type of clause that the federal government uses in the Commerce Clause to say that they have broad powers. But it's limited in the California context to a state of actual public emergency. Again, there's very similar statutes in every state in the United States giving authority to public health officers or certain other officials, maybe a mayor, maybe a governor. Someone's got an authority in a crisis, in a time of declared emergency, that they don't have in another time. Now, that doesn't suspend the operation of the Constitution, but what's really, really important for you to understand is that the idea that the United States Constitution applies against state actors is a very recent vintage. 1940s is when it finally came to a head. By that time, by the 1940s, it was really the 1930s and 1940s, a little bit in the 20s, but by the end of the 1940s, the Bill of Rights, and most of it, not all of it, but most of it was interpreted to apply to the states through the 14th Amendment. Now, this is also something that a lot of legal scholarship disagreed about when it was happening. The 14th Amendment applies the same due process standard against the states as was applied against the United States, the federal government. It was actually, and most of you will probably know, but I want to say the 14th Amendment was added to the Constitution in the middle of the Civil War by Abraham Lincoln in response to the states' rights issue, where some states were saying we have the right to keep a whole race enslaved, treat them like property and like something less than humanity. And that's at the height of natural law jurisprudence in the United States. And that's a type of civil rights violation that's nothing like what we're seeing today. I mean, compared to that, I mean, if you just think about that, the idea that it was protected under the Constitution for states in what was by and large the South to say that anyone based on the color of their skin wasn't human, wasn't entitled to any rights, was considered to be property, and that went on in the United States for a long time. I mean, if you think about when the Constitution was written, really when the Revolution started until that happened, I mean, it was over 80 years. You hear Abraham Lincoln's speech 40 years ago. Our fathers brought forth this thing dedicated to the proposition that all men are created equal. And it took them over 80 years to get to the point where anyone was able, because there was a lot of people who wanted to, from the founding, who wanted to abolish slavery. But change in the United States and movement politically in the United States was always meant to be incredibly difficult. And bringing it about at a national level required a Constitution amendment, which is a very difficult process to enact. And a lot of people have disputed the way that it was enacted then. But the 14th Amendment applied the due process standard and created what's called the Equal Protection Clause. And through those things, courts ultimately interpreted, and really led by Justice Hugo Black in the 20s, 30s, and 40s, they interpreted that all the fundamental rights guaranteed by the Constitution apply against every level of state and local government. And it's a real stretch for the First Amendment. It's a real stretch, because if you read the text of the First Amendment, everyone's been reading the First Amendment. I've seen a lot of people online, when they go live, they read the First Amendment. But the first words in the First Amendment is Congress shall make no law. It doesn't say a state legislature or a state governor or a county officer. It says Congress, and that's very specifically defined in the Constitution to mean the federal Congress shall make no law prohibiting the free exercise of religion or abridging the right of the people to peaceably assemble, but it's Congress. And so to take the First Amendment and apply it to the states, the Supreme Court had to do a lot of really questionable reasoning to get to that point. But for better or worse, it's now settled in Supreme Court precedent. And for all time, the Supreme Court intends to apply the First Amendment to state and local government. Again, there was a time where it didn't apply. A great case was in the late 1800s. There was a question about whether or not the Assembly Clause of the First Amendment applied against local actors. In that event, the Ku Klux Klan became aware, and they were pretty much the local government in the area, and they became aware that there was a meeting of African Americans at a city hall, and they were having a proper meeting, assembling for a proper purpose, and they massacred them. And they killed hundreds of them for assembling and for daring to come together. And this was post-Civil War, for daring to, you can look it up. It's the first assembly right case that the Supreme Court ever considered. And the Supreme Court of the United States said that the First Amendment does not apply against the Ku Klux Klan or against local or against state governments, and that the people who were surviving and family members of the people massacred had no standing to bring a constitutional claim against those actors. We're dealing with nothing like that. No one is going and massacring people who are trying to assemble. No one's going and trying to enslave people or say that they're property. What's happened in the past, another example is, and again, when you're looking at the Assembly Clause, is the Red Scare in the 1920s and in the 1950s and in the period in between. A lot of state and local governments, and the federal government too, got involved trying to shut down meetings of what were considered to be communists or people who were subversive to the interests of the United States. And based just on the suspicion of someone being a communist, they were deprived of rights, they were pulled before panels of government to answer for themselves based on their political viewpoints. Another example, it's a decision of the Supreme Court called Korematsu. During World War II, the federal government decided that it had the power to take every man from Japan, every man, woman, and child from Japan, and put them in internment camps here in California. I visited those internment camps. One of the beauties about the United States is we tend not to do a lot of the same atrocities elsewhere because we have separation of powers. And those internment camps are some of the best internment camps from a quality standpoint that you'll see when you talk about internment camps. But it's still an internment camp where people are basically treated like animals and cattle, and it's not something that is looked on by anyone as a bright mark in the history of the United States. That's a whole race of people. And again, a lot of actions have been motivated based on race in the past. That's a whole race of people deprived of liberty, deprived of all of their fundamental rights because of what was considered at that time to be an emergency. So the idea that depriving people of rights is happening for the first time or on the worst scale in the history of the United States, or that this is some grander conspiracy where people are trying to take control of the whole United States population. It's simply not based in reality, because if you look at it, what we have is exactly what the Founding Fathers intended. We have a federal system where the federal government's instituting guidelines and the states are free to respond however they want to respond. And has there been overreach? Absolutely. There's no question about it. Even the Attorney General of the United States and the United States Department of Justice has weighed in a number of different cases and said they're very concerned about things that are going on. And they're looking around the nation at civil rights violations and different things that are going on and saying there's instances of overreach. But by and large, every actor is motivated by one desire, and that is to stop the spread of COVID-19. Whether rational or irrational, reasonable or unreasonable, a good policy or a bad policy, it's ultimately up to our political decision makers to make those decisions. And they do it based on what they believe to be the will of the people. And in this case, 94% of the people in the United States of America seem to favor asking people to stay at home. If you look in California, Governor Gavin Newsom has had, on April 10th, he had an 82% approval rating in California. When I looked on May 1st, he had a 70 or 71% approval rating. That means, by and large, most people in California are approving of what the state is doing. And again, the state is within its rights to make the decision about how to respond. Now, it's outside of its rights to single out the church. It's outside of its rights to prohibit all kinds of assemblies. That's outside of what the state can do. And again, the Department of Justice at the federal levels weighed in about that. We have a lot of people filing lawsuits. That's what the court system is for. That's another part of our system. So the goal of the United States system of government was what's called separation of powers. It's been written about a lot. It's been applauded over history. Everyone who's looked at it has said this is such a good idea because the separation of powers prevents power from being brought into the hands of a single man. Because we know that power is something that corrupts, and that's an idea that everyone recognizes. And separation of powers was created on multiple levels. We have separation of powers between federal government and states, and then we have separation of powers within the federal system, 3 different branches of government. And there's been a lot of blurring of the lines over the last 150 years between the executive branch and the legislative branch through the creation of what a lot of people refer to as a 4th branch of government, agency branch, CDC, Department of Homeland Security, the National Security Agency, the FBI, all of these, the CIA, all of these are agencies, and there's a lot of them that are created in the federal government by Congress. So this isn't absent a political body. This is done by Congress over a long period of time, well over 100 years, about 150 years now, where they've been creating agencies. The first one was created to regulate railroads. And now we've got so many, not just regulating specific industries, but regulating every industry, like the Environmental Protection Agency. It doesn't just, you go from regulating just one industry, like railroads, to regulating every industry. And what Congress decided back in the late 1800s, a lot of change happened there. Congress decided that its members didn't have the ability to know what's the best regulation for railroads. So they created an agency of people who are experts in railroads, and there's a lot of criticism about agency capture because most of those people have a financial interest in railroads, but that agency gets to regulate the way railroads act. And not just railroads, but that's how every agency ultimately begins, is Congress saying, well, we're elected officials and we're not smart enough to regulate this certain industry, so we're going to pass that duty on to experts. Center for Disease Control is a great example. The National Institute of Health. Congress said, well, we got to find people who are experts in epidemiology or in infectious diseases, and they have to be the ones to tell us what to do in response to a disease. So they've spent a lot of time preparing for a pandemic and creating a plan, and they've actually written documents about pandemic response, the best way to destroy a disease, including recommending social distancing guidelines, stay-at-home orders, and different things. And in those documents, some of them, one of which I recently read, was they're asking the question, well, how do we do this within the confines of the Constitution? So they're asking that question as kind of a starting point, but then they're looking at it from just a purely scientific standpoint and saying, well, how do we stop this disease? They're not really considering all the incidental effects. And it really breaks down when you talk about all the levels of government involved. Maybe someone at the national level considered incidental effects, someone in the Homeland Security Agency, because again, these are different agency bodies that have to somehow find a way to work together, and it creates all kinds of confusion. But ultimately, the people who are making a decision come at the local level. San Diego County's order is so much more restrictive than California's order, which is so much more restrictive than the national guidelines. And that's the way it was intended to be. And when people don't like it, the way that the proper response is to try to move people politically to vote in different policymakers. And ultimately, time is what tells in this case. But in cases of overreach, what's supposed to happen is people whose rights have been deprived go to court, and the court steps in and helps local government especially understand what their limits are. Because even in the context of what's going on in San Diego County, we have a public health officer who institutes an order, but then there's sheriffs and police officers who have to enforce that order. And that's a whole nother level of decision making. For example, in San Diego County, the sheriff decided that he would not enforce the order against gun stores because of the Second Amendment to the United States Constitution. And he wrote a statement about that. He didn't use his discretion when it came to churches. And our church in particular was singled out for enforcement mostly because of the awareness that the Sheriff's Department had of what we were doing. And that's something that, again, is a lot of discretion, but a power structure that's completely varied. It's more centralization of power than was intended, but by and large, what we see is we see different responses. If this was really a move to control the United States population, South Dakota would have the same response as California, New York, Florida, Louisiana, and every other state. But the federal government recognizes that they can't do that. And there's no international organization that can come in and tell different localities in the United States what they should do. Is there corruption? Is there money changing hands? Yes, absolutely, and there always has been. George Washington, as much as I admire him, and I've spent a lot of time reading his writings, he was involved in a lot of self-dealing around water rights on the Potomac River around his perennial home at Mount Vernon. And it was a notorious instance of self-dealing. You can look into that yourself. And there's been a lot of others throughout United States history. And it's not by any means perfect, but it's designed to decentralize power, to limit the amount of self-dealing or to limit the impact of bribery. If you bribe one person in the legislature, that one person doesn't have the power to change what the national or state policy is. And so what I really want to emphasize, and I'm out of time here, what I really want to emphasize is that the system that we have in place is working the way that it was intended to work. The deprivations of rights that we see here now pale in comparison to past deprivations. I mean, when you talk about, again, and I want to reemphasize, when you talk about what was done to African Americans in the 1800s and even into the 1900s through the civil rights movement. If you just look at the civil rights movement and what police response was to that, what we're dealing with now, we've got police officers who aren't doing what they did then. I mean, the beatings that happened, the false imprisonments that happened, everything that went on into the 1960s, I mean, we're dealing with a much milder set of circumstances and a much milder type of deprivation than has gone on in the past in the United States. As far as I know, no one's getting beaten, no one's getting arrested, and the response to law enforcement has been the most questionable and concerning thing. There was the report that just came out about someone shooting a security officer because they were trying to enforce the mask ordinance. And all I'm trying to say is that that type of response and the idea and the panic amongst our community about what's going on is unjustified. And by and large, everything is happening the way the founders intended, with a very small area of overreach. And that area is particularly concerning in only some states. In other states, it's not nearly as much. And again, that's what the founders intended. And what we're going to see in response is everyone moving to make policy changes. There's probably going to be new laws enacted. The courts are going to get involved. And that's what the United States was intended to do when God was involved in the miracle of the founding of the United States of America. And I believe the United States of America is going to continue to preserve those freedoms and rights and continue to be a beacon around the world of what that looks like. But we, especially as a church community, have to lead the way in that. And I'm out of time, and thank you guys for coming in, and we love you very much. Turn off the camera.